Good evening, hello and welcome. You're with the news today, Tuesday night, your primetime destination. Law above faith or faith above law? What does the Places of Worship Act say? We'll be diving into the legal debate on the Gyanvapi Mosque tonight. Also, the wheat export ban, knee-jerk reaction, the question to be asked on a day when wholesale price index has reached new highs. The country's top agriculture economist, Professor Ashok Gulati, will be joining me later today. But first, as always, the 9 headlines at 9. The Supreme Court orders the protection of an alleged shivling area inside the Gyanvapi Mosque, but says namaz must go on unhindered inside the mosque. The top court refuses to stay the Varanasi court proceedings just yet. We'll hear the matter again on Thursday. The Varanasi court sacks the survey commissioner for allegedly leaking the Gyanvapi survey report, claiming there was a shivling inside, allows the survey team to submit its report findings now by the 19th of May. CBI raids former Union Minister P. Chidambaram's son Karti in a fresh bribe for visas to Chinese workers case. Karti accused of taking rupees 50 lakh bribe. The Chidambaram say the cases are politically motivated and timed to create confusion despite no evidence. India rejects Pakistan's resolution on Jammu and Kashmir delimitation. Ministry of External Affairs says Pakistan has no right to interfere in internal matters or to pass farcical resolutions on India's territory. April wholesale inflation surges to 15.08%, in contrast with 10.74% last year. Inflation triggered by rising price of mineral oils, basic metals, crude petroleum and natural gas. It's the 13th consecutive month where WPI has been on the rise. Rupee hits a record low against the US dollar at 77.73, recovers to close a little higher at 77.79. This as Brent crude futures also surge ahead. Centre eases restrictions on wheat exports after much criticism. Lets through a shipments registered before 13 May. Global wheat prices touch an all-time high. More than 2 lakh people affected in devastating floods in Assam. Hill district cut off after a landslide. Rail and road links affected. 20 districts battle flood fury. Other states in the northeast like Manipur also facing floods. Ukrainian military declares end to combat mission in Mariupol as more than 260 fighters evacuated from a steel plant. Moscow vows to liberate eastern Ukraine's Donbas region. But our top story tonight comes from the Supreme Court once again, which today ordered to protect the area of the shivling that has reportedly been found inside the Gyanvapi Mosque. But the Apex Court also made it clear there will be no restrictions on Muslims offering namaz. They must be given unfettered access. This on a day that the Varanasi court removed the controversial court-appointed commissioner Ajay Mishra for allegedly leaking the Gyanvapi survey information to the media. So, how did the Gyanvapi case play out in 2 courts? It's our top story tonight.
The shivling found at the Gyanvapi Mosque, as claimed by Hindu petitioners, will remain protected. The Supreme Court has ordered the Varanasi District Magistrate to ensure the safety of the claimed shivling. The Apex Court, hearing a petition by the Anjuman Intizamiya Masjid Management Committee against a Varanasi court ruling that provided protection, stayed the other parts of the order on Tuesday. The topmost court of the country said Muslims will be able to offer namaz at the mosque without any restrictions. The 20-person cap ordered by the local court has been stayed. The Supreme Court will now take up the matter on Thursday next. During the Tuesday hearing, the Mosque Committee argued that the commission appointed by the Varanasi court is yet to submit its survey report. Advocate Huzaifa Ahmadi said the Varanasi court passed its order based on the plaint filed by the Hindu petitioners that claimed a shivling was found. The Mosque Committee claimed their side was not heard by the Varanasi court when it passed an order on Monday. Ahmadi also argued that all orders passed by the lower court were in violation of the Places of Worship Act that ensures status quo as of August 15, 1947. Solicitor General Tushar Mehta, appearing for the Uttar Pradesh government, urged the Supreme Court to shift the Wazu Khana, the area where Muslims wash their arms and legs before namaz. This request was denied. Meanwhile, the Varanasi court on Tuesday removed Ajay Kumar Mishra as the court commissioner appointed for the survey of the Gyanvapi Shringar Gauri complex. Ajay Mishra was removed for leaking survey information to the media.
विशाल जी ने जो किया वो गलत किया है।
क्या किया उन्होंने?
यही जो हमारे ऊपर आरोप लगाया, मुझे नहीं था, उनको अगर बताना चाहिए था, मुझे कोई आपत्ति उनको थी मुझसे जो है, तो कम से कम बात तो किए होते बैठ के। अपने उठने के लिए किसी को गिराना नहीं चाहिए।
The court battle over right to pray at the Gyanvapi Mosque has sparked a political fight.
The order of the trial court is completely wrong, unfair, illegal, which we hope that Supreme Court on the next date of hearing will completely stay that order.
What the Honorable Supreme Court and the bench of Justice Chandrachud and Justice Narasimha has been pleased to order is that this area where a shivling is supposed to have been found will be protected as had been directed by the learned trial court.
The legal battle will resume Thursday now when the Supreme Court takes up the matter next. The Varanasi court has also asked the commissioners to submit their video survey report of the Gyanvapi Mosque by that time. Bureau Report, India Today.
And joining me now, my first guest tonight, Vishnu Jain, lawyer in the Gyanvapi case for the Hindu petitioners. Appreciate your joining us, Mr. Jain. Now, the controversy today comes over the entire issue of videography of the survey and the manner in which the findings were leaked in advance that there was a shivling there. You could have gone to the court. You have gone to the court based on that leak report. Now the court commissioner is removed. Questions will be raised. Is this entire survey been done to prejudice, in a way, the court proceedings with the leakage of this report?
No, there is no question of any leaking of the report. Yesterday, when the survey was being conducted and the moment the survey got over, my clients and the plaintiffs, they saw the shivling, and we felt, and our legal team felt that there's an immediate need for protection orders. And therefore, as per Order 39, Rule 1 of the CPC, there is a provision under Order 39, Rule 1 of the CPC that if there is a danger of destruction of the suit property, then immediate interim relief can be granted ex parte. So therefore, in light of the provisions of Order 39, Rule 1 of the CPC, we approached the Honorable Varanasi Civil Court and we immediately requested the Varanasi Civil Court that since it is a very important piece of evidence for proper adjudication of the matter in issue, therefore, this shivling which we have found in the Wazu Khana must be protected and must be preserved, must be sealed. And that order was passed by the Honorable Varanasi Court, and the said order has been maintained by the Honorable Supreme Court.
Mr. Jain, today the Varanasi Court has removed the court commissioner. And the argument being made is that the court commissioner leaked confidential findings by hiring a private cameraman, and the petitioners, instead of maintaining the confidentiality of the report, went ahead, made it public that there was a shivling out there, thereby prejudicing the case. What happens to the confidentiality of the court hearings on a sensitive manner, Mr. Jain?
No, it is absolutely wrong. It's a total misrepresentation of the order. Kindly read the order which has been passed today. The ground of removal of the Advocate Commissioner is that the Advocate Commissioner, Mr. Ajay Mishra, had taken one private person, Mr. R.P. Singh, along with him in this entire survey process. And after he came out of the survey, he briefed the media about whatever he saw in the survey. And therefore, on giving media bites and giving media interviews with regard to the survey which was happening, Mr. Ajay Kumar Mishra has been removed. There is no question of, there is no involvement of the plaintiffs in this, and nothing like that. What you are just saying is mentioned in the order.
The charge, in a way, Mr. Jain, that you will have to address at some stage is the attempt that is being made through the media to influence the verdict even before a report on a sensitive matter is submitted and made public. That you are conducting a media trial on Gyanvapi Mosque by claiming that there was the shivling there.
See, there is no question of prejudicing anyone. The lawyers and the legal team of this entire case, they have not even uttered a single word so far as this entire survey is concerned. and those who have uttered those who have briefed the media about whatever survey is going on, they have been strict action has been taken against them, and they are not the plaintiffs of the case. All our 5 plaintiffs have said nothing about the survey which has been conducted. And apart from that, no lawyer of the case has spoken anything about the survey. I myself have not spoken anything about the survey. And only the aspect of shivling I have spoken, because we have filed an affidavit in the court. We have moved the court seeking urgent interim relief for protection of the shivling. Therefore, when the court passed that order, then briefing was done, and that was not with regard to the survey. Whatever we found in the survey, nothing has been told by the legal team or by the plaintiffs.
The larger question, Mr. Vishnu Jain, is whether the survey per se is a violation of the Places of Worship Act, which says status quo must be maintained on all places of worship as they stood in 1947. The petitioners who've gone to the Supreme Court claim that the act protects the religious character of the place and says therefore conducting the survey was ab initio illegal, aiming to change the character of the place of worship. How do you respond? Because this is now also going to become critical in the Supreme Court, which is hearing the constitutionality of the survey per se.
It is absolutely erroneous and a misplaced argument, because if you analyze this entire matter, this objection was taken by them on 5th of by 5th of April. The Honorable Trial Court had clearly mentioned that right now we are not going to change the nature of the property. If one side is claiming that this is a temple and the other side is claiming that this is a mosque, then first we have to ascertain that what is the religious character of the property in question, and then only there will be any further question or issue with regard to attraction of Places of Worship Act. When this preliminary question has not been decided, you have assumed, the Muslims have assumed that this is a mosque. Since they offer namaz, this is a mosque forever. And they want to shut the voice of the masses of this country who are showing proof that there is a huge Hindu structure beneath this mosque. So the question is, Rajdeep, that if two sides are claiming on a particular issue, first that issue has to be adjudicated, and after adjudication of the issue, the attraction and the question of Places of Worship Act will arise. Because if you will look into it very minutely and deeply, Section 4 subclause 2 of the Places of Worship Act uses the word religious character, and the religious character which was existing on 15th August 1947 has to be determined first. Then only Places of Worship can be attracted. Now the problem is that the entire Muslims and the Anjuman Intizamiya is shying away and running from the survey because they know that what is the religious character of this property in question. I am ready to put in evidence. I am ready to prove my case through evidence. But the question is, what's the fear? Why Anjuman Intizamiya is so fearful to enter into trial? They just want the protection of a parliamentary law. And ultimately, Rajdeep, they see this entire issue on a holistic point of view. Ultimately, what are you seeking for? You want to shut the doors of the court for us? If we are saying that this is a temple, you say that no, boss, you cannot say that this is a temple because Places of Worship Act restricts you. So you can't go to the court. Okay, if I can't go to the court, then where should I go? I'll go to the parliamentarians then. I'll ask the parliament and the officers in charge in the helm of the affairs of this country to enact a law and declare Kashi Vishwanath to be a Hindu temple. Then the question will be, will you abide by that? That will also be a law passed by the parliament. So the question is that if two communities are saying that there's a dispute at a particular place, the only forum by which it can be adjudicated is a judicial process. And you cannot say that you cannot have a judicial remedy at all. What Mr. Owaisi and other leaders and Anjuman Intizamiya are asking and seeking and asking this question is that no, you will not have a judicial remedy. No case in the court will be filed. Just shut your mouth and keep mum. That cannot be done.
Vishnu Jain, for setting in context where your claim is on the petition, I appreciate you joining us. You're raising several contentious issues, especially around the Places of Worship Act. Let me therefore widen the debate. Law above faith or faith above law is one question that's often asked. But more specifically, is this a survey a violation of the Places of Worship Act? Is there a bid to change the religious character of the Gyanvapi Mosque where namaz goes on? Will the government now relook at the Places of Worship Act and repeal it again through Parliament? Joining me now, Bishwajit Bhattacharya as former Additional Solicitor General Nalin Kohli is Advocate Supreme Court as well as, of course, Senior Advocate Supreme Court as well as a BJP spokesperson, and Shadan Farasad is also Senior Advocate at the Supreme Court. Appreciate all of you joining us. Nalin Kohli, let's take that. You heard Vishnu Jain suggesting that the Places of Worship Act cannot stop a petitioner from claiming the right to worship in the Gyanvapi mosque structure where they claim the shivling exists, a temple existed. And is saying that if necessary, we will go to Parliament again and repeal the Places of Worship Act that allows for status quo to be maintained. Your response, are we saying now that the Places of Worship Act should be consigned to the dustbin of history?
No, Rajdeep. I think as an advocate, and I think you'll have to also see it from the correct perspective of law. A political debate might be different, but we have, of course, the responsibility of putting out the correct position here. So let's go one by one. Essentially, any act or statute is but a creation of the legislative process. Now, that may be Parliament for a law which is across the land, or it may be the state legislature. And it's always in a given set of circumstances. Secondly, no act can be permanent in its exact character. The Constitution of India's first amendment was in 1951. So therefore, there will be amendments as the situation or circumstances so require. There will be acts and statutes that will be also discarded. If I take the Narendra Modi government's track record over the last 7-8 years, some 1500 plus archaic or not required statutes have been done away with. So the legislative process has its own dynamics. It will continue. The legal process is different. The Parliament cannot, for example, change the basic structure of the Constitution of India. But anything else can be changed. However, that is subject to judicial review, which is part of the basic structure.
Can I make it much? No, can I make it more? Can I, sir, make it more direct? Can I make it more direct to you? Is the place,
I don't agree with this.
Sir, at the height of the Ayodhya dispute, the Places of Worship Act was brought by the Narasimha Rao government to ensure it claimed that all religious structures would have to maintain the status quo as existed on April 15, 1947. Are you telling me, Nalin Kohli, that in your view that act should be now amended because a new situation has arisen in Kashi Vishwanath? Today it's Kashi Vishwanath, tomorrow it could be some other structure.
No. No, I haven't said so. And as a practicing advocate, I understand that dynamics. For example, there will be a set of people, as today, for example, Mr. Ahmadi was arguing for his clients, that the places of, after all, he makes his case based on something. There will be a set of people who will say that the Places of Worship Act cannot be changed. Per contra, the other side is entitled to raise the point that can you eliminate judicial review from something, or can we not challenge the act? So there will be different arguments.
What is your view? What is your view?
The Honorable Supreme Court, as Justice Chandrachud and Justice Narasimha passed the order, have decided they are going to hear the matter further.
Okay.
What's my view? My view is in any case, it doesn't matter whether it's the case of today or another case tomorrow. In any case, both sides are entitled to put their points of view. In any case, one side is going to argue on the validity and the 1991 Act being cast in stone.
Right.
And it is equally true that the other side will definitely argue that nothing can be cast in stone, and a relevant fact as a shivling, as is being believed to have been found there, can be ignored. So this is a matter that we are best leaving it to the courts.
Okay. Let me bring in Mr. Farasad. Mr. Farasad, the arguments made in the Supreme Court today by Mr. Ahmadi for the petitioners who had gone to the court saying stop the survey is that this is a violation of the Places of Worship Act, because allowing this survey to take place, videography to take place itself means a changing of the religious character. Isn't that of the place of worship? Isn't that a bit of a stretch? The fact is a survey is taking place. The namaz will continue, as Justice Chandrachud said. Why then do the petitioners believe that this act of the survey itself is a violation of the protection, the Places of Worship Act?
So first thing first, Places of Worship Act is on the statute book today.
Yes.
If Mr. Kohli's party in the future wants to amend it, they are welcome to do it. We'll test it then. Today, that act is there on the statute book. So it has to be complied with, right? So that's point one. Now, what does the act say? The act is absolutely clear. It says that the character of any religious place of worship as it existed on August 15, 1947 shall not be changed. There was one exception carved out, and that was the Ram Janam Bhoomi Babri Masjid. Apart from that exception, there are no other exceptions carved out in that act. Now today, the survey has been ordered in a suit in which there is a application pending that this suit at all is not maintainable. Trial court does not bother deciding that application. So in a non-maintainable suit, which is per se without jurisdiction, they go ahead and order this survey. Where is the question of a court without jurisdiction ordering a survey? Where is the question of a court which does not address itself to the bar of the suit in the Places of Worship Act first and order a survey? So first thing, it is essential to understand that this is
It's not a title suit. Mr. Farasat, I might point out it's not a title suit here. We are not discussing, like in the Ayodhya case, we are not discussing.
It doesn't make a difference.
It's not about title here.
The bar applies, Rajdeep, it may not be a title suit, but it makes no difference. The bar applies to any legal proceeding. That's the language. I have the act open in front of me.
Yes.
Section 3 and 4.
I have it also.
Section 4. Correct. So it makes no difference. You are right. They can craft the prayer whichever way they want and frame the suit whichever way they want. The bar is absolute.
Okay.
Now today, if that bar exists, where is the question of this court ordering this? And there is just let me complete. Just before that, let me complete. There's a very good reason behind this act. The reason behind this act is that we have layers of history. We had Buddhist rulers in Ashoka. Then Mauryan Empire was changed by Hindu rulers. Now there are cases and claims that they were effectively Buddhist shrines and temples were removed and Hindu temples were installed. Is Mr. Naren Kohli open to that being examined? There is a very good reason why this is.
Let him respond. Let him respond to your pointed question. You made a pointed. Let him respond to your pointed question, and then I'll go to Bishwajit Bhattacharya. The pointed question or the point put forward by Mr. Farasat is: how far back are you wanting to go? How far back the law can go? There was a reason for the Places of Worship Act. Today we are talking about temple mosque. Tomorrow the Buddhists will turn around and say there was a stupa over which a temple has now been built. That's also possible.
So that argument is more out of enthusiasm, less out of legal foundation.
Yes.
And I'll demolish it on 3 counts again. The first is that the parliament, when it passed that act, it should be recalled, there was no major discussion on it. In fact, the BJP registered its protest and walked out. That's a political response since we brought in a political aspect. Number 2 is the Places of Worship Act also carves out exceptions within the act itself. And that's section 4.3. One only has to refer to 4.3, which clearly says that nothing in this subsection XXX will apply to a place of worship referred to in the said subsections, which is ancient and historical monument or an archaeological site. Now, therefore, who's going to decide this? Not on a TV debate between 2 heated protagonists. It's going to be decided by a court of law. And I think we should respect it. And the third argument, that when a suit is not maintainable, per se it's an illegal suit, that is their application under Order 7, Rule 11, which is rejection of plaint. They are entitled to say that it's not maintainable, but there is no court order holding that the suit is not maintainable. That has to be tested. So any suit, anybody can say that this suit is not maintainable. Only after arguments are perused, arguments are heard, the court will decide. So how can Mr. So-and-so decide on this? I have filed an application, it's not maintainable, so it's not maintainable.
Mr. Farasat, you want to answer the exception to the rule because under Place of Worship Act 4.3, any place of worship referred to in the said subsection which is ancient and historical monument or an archaeological site or remains covered by the Ancient Monument Sites and Remains Act for the time being in force, this will not apply. So I could claim it comes under that, Mr. Farasat.
Yes,
there
so
are
the
exceptions.
Answer to that is simple. The reason for that exception, I'm quite happy you asked that question. The reason for that exception is that if there is a temple or a mosque which is dilapidated, which has to be protected, in which if prayers are to be carried out, it will further worsen the position, the physical structure, then you can stop it. ASI or somebody else can take it over because it's an archaeological monument and you can stop prayers. That's the purpose of that exemption.
Okay.
This exemption is only to section 4. It's not an exemption to section 3.
Okay.
Section 3 is the absolute bar, which is the place of worship cannot be changed. And therefore, the exemption is only to protect the monument and not to change its nature of its character of its worship.
Okay, let me take that then to Bishwajit Bhattacharya. Bishwajit Bhattacharya, there are also PILs at the moment before the Supreme Court on the Place of Worship Act. And they claim that the cutoff date of August 15, 1947 to maintain status quo is arbitrary and violative of religious freedoms guaranteed under Article 25, 26 and 29 to Hindus, Sikhs, Jains and Buddhists. Do you agree that 1947 is an arbitrary date and therefore the Place of Worship Act itself will have to now be reviewed by the Apex Court, or dare I say amended by Parliament?
You see, 1947, 15th August was the Independence Day of India.
Yes.
And it was a watershed moment. It was basically a watershed moment on all the wounds and wrong, all the historical wounds, historical injustices. It was expected that it will come to an end. So to that extent, whether the date of 1947, 15th August is arbitrary, I don't think it will be arbitrary. The intention of legislation was that...
Is it a violation of Article 25, 26 and 29?
Let the dead past bury its dead.
Is it a violation of Article 25, 26 and 29, Mr. Bhattacharya?
No.
The right to practice violative of religious freedoms guaranteed under Constitution.
You see, Rajdeep, the basic point which I think we are tending to miss is the wordings is that 1991 Place of Worship Act of 1991. So place of worship does not mean only Hindu or only Muslim or only Sikh or only Isai. It's a very broad-based act. Today, incidentally, it happens to be Hindu and Muslim. Tomorrow, it may be other. So the Parliament, in its own wisdom, this particularly Article 372 of the Constitution of India has basically sanctified it. Of course, this is a 1951 Act. And one point I would like to make is, which perhaps the language is, whether the court is shut or not. You see, the language of Section 4 is that no suit shall lie. Okay. And all the pending suit shall abate. The word shall abate has some meaning. And when a suit is filed, whatever may be the final prayer, if there is a question mark about the basic maintainability of the suit, then I think that question mark should in all fairness be cleared first. Once it is held by the court in its own wisdom, subject to appeal that the suit is maintainable, then of course the interim order or any subsequent order can be passed.
Sir, but there are trials. Mr. Bhattacharya, the court in Varanasi is already hearing the matter, right? The court in Varanasi has already called for the survey also in the next 2 days. What can the Supreme Court then do? Can the Supreme Court call a complete stay on all proceedings of the lower court till it has heard the matter? Is that what you are saying?
I would not like to speculate what the Supreme Court can or cannot do or shall do. I will only remind the nation that on 9th of November 2019, in a far more contentious issue, the Supreme Court basically rose to the occasion and discussed this act also. This 1991 Act, which is now being debated before your most, illuminating discussions. Both the panelists are my very close friends, so therefore, and they are very distinguished lawyers. It's a very, very illuminating discussions we are having. But once a 5-judge constitution bench of the Supreme Court on 9th of November 2019 rose to the occasion, and so we have traveled up to 2022. There has not been any kind of disagreement anywhere, and the Prime Minister, Mr. Narendra Modi, made a categorical statement after that judgment. This is neither a victory or defeat for anybody. I think in the same spirit of peace, prosperity, liberty of thought, worship, belief and faith, Supreme Court will once again rise to the occasion and solve the problem.
Sir, that's your interpretation. Some will say Supreme Court... Sorry, sir. Mr. Bhattacharya, some will say Supreme Court opened the floodgates on November 2019 by deciding on the Ayodhya case, ruling in a sense that the faith of the religious community which believed it was a temple of Ram needed to be given primacy. In a way, you have opened the floodgates. You have in a way, let's be clear. I'm sorry. I am also a lawyer, sir. I am also a lawyer. There will be those who will argue the Supreme Court has opened the floodgates in this country. And therefore, how do you stop it now?
Section 5 is the answer. Rajdeep, I have also equal amount of respect for you. Section 5 is the 1991 Act is the answer. Section 1991 says the Act shall not apply to Ram Janmabhoomi. There is no question of any floodgate. And I told you, I think you have missed the point which I am making. Supreme Court in the Constitution Bench judgment on 9th of November 2019 extensively discussed, I have read it. In fact, when the invitation from your channel came, from your office came at 4 p.m., I refreshed myself. I read that scintillating judgment of Constitution Bench. It has discussed, so 1991 Act stands. As long as 1991 Act stands, that is the law, and so therefore...
So you are saying the only exception was Ram Janmabhoomi. All other places of worship, status quo must be maintained.
So therefore, I respectfully differ with you for using the word opening the floodgate. I'm sorry, I cannot agree with you.
I am referring to the singular. Sir, just a minute now. I am referring to the singular issue of whether faith has to be placed above law. Nalin Kohli, a final word. You are a politician as well as a lawyer. The fact is, the same BJP in the 1990s, Atal Bihari Vajpayee, among others, said, our focus is Ayodhya. It is not about Kashi and Mathura. Now suddenly you are in power. You've got 300 plus seats. You've changed the goalpost.
First, there is an assumption here that the BJP has filed a suit. It isn't. The Ram Janam Bhoomi was an outcome of the Yatra itself, which took place in 1990 when L.K. Advani ji had done it and the BJP had rallied around it fully. So there is a background. Where is the BJP which has gone to court? Where has the BJP rallied anything on this? It hasn't. Let's get the facts straight. This suit was filed in 1991, which is basically a suit for a declaration, asking basically permission to go ahead, do darshan and do the various kind of prayers. It's filed by somebody there, a private citizen.
Okay.
Are we saying that private citizens in this country, Hindu, Muslims, Christian, Buddhist, Parsi, anyone, can't file a suit of what they desire? Every day suits are filed. Every day things go before the court.
Okay.
Every day there are two sides or more sides in a suit. So how can you say that the BJP or another party is behind all of that?
Can I therefore get Mr. Farasat?
Entitled to approach the court.
Can I get therefore Mr. Farasat therefore to give a final word? A final word. Let him have a final word.
Argument is basically to think the BJP is behind it.
Okay.
Sure.
Mr. Farasat, the fact is that you've got a situation now where all that is being asked is the right to worship. It's not as if, unlike Ayodhya, let's get this clear, it's not as if they are asking for possession of the mosque area. It is for the right to worship, to have a passage, to have unfettered access to the mosque to worship. Can that not be resolved legally?
Yeah, no, so I think, you see, the point is it makes no difference because these are cases where there is effectively a creeping acquisition. Now, today they have managed to open something up and you have a supposed shivling there based on which they have already created a narrative to their advantage. So these are processes. I mean, Ayodhya also was done over a period of 30 years and much more than that, but 30 years combined with aggressive politics. So, you know, I don't think anybody on the side of BJP or the parties which are on that side of the spectrum are in a rush.
Okay.
So this is an opening for them. That's how they look at it. They will very well wait it out 5-10 years, but make no mistake that this is the same process of creeping acquisition and will continue in religious places after religious places.
Okay, let me leave it there. We have got a sense of where the law stands. That contentious issue of faith above law will remain. I'm afraid I've run out of time. I have another guest waiting for me. We will carry forward this debate. There'll be many more occasions. This is not going to end just here. Nalin Kohli, Bishwajit Bhattacharya, Mr. Farasat, appreciate your joining me here on the news today. Let's turn to the question that many should say should have been my lead story today, because wholesale prices have risen to an all-time high in the country. For the 13th consecutive month, wholesale inflation has risen. It's now reached 15.08% in April versus 14.55% in March. The surge primarily due to rise in price of mineral oils, metals, crude petroleum, natural gas, food and chemical products. 15 consecutive months. Now, Leading the way also is wheat prices. Wheat prices have now reached an all-time high. And this comes amidst the government's U-turn. Remember, the Narendra Modi government last week was talking about exporting wheat across the world. Then suddenly on Saturday, the government decides to ban the exports of wheat. Now there is criticism of the government's act, especially from farmer groups who are saying they are being denied an opportunity to take advantage of the situation. Take a look at this ground report from Punjab.
Parched in March and banned from exports 2 months later. For the farmers who could afford to stockpile their wheat output in order to chip in to bridge the global supply gaps in the future, the move to stop its exports is an unwelcome step. Already suffering a lower yield this season, between 10 and 50% by some estimates, many farmers of Punjab sold their wheat crop to private traders for exports at prices somewhat higher than the MSP. And those who placed their output in reserve in the hope that they will get a better return if prices increased further, the ban has dashed their hopes.
अब दोबारे ये गोडाउन से निकाल के महंगे भाव में बेचेंगे तो गरीब का नुकसान होएगा और जो हरासमेंट है किसान की वो भी बढ़ती चल जाएगी। ठीक है सर। इसलिए हम चाहते हैं कि ये इसका बैन हटना चाहिए।
India is the largest producer of wheat, most of which is consumed domestically. This year, the country planned to export 10 million tons of the grain to capitalize on supply disruptions from the war. But the blistering weather, a record high inflation, and the conflict between the world's two major suppliers of wheat led India to abruptly restrict exports of the grain.
While at one hand, the farmers were eagerly waiting for a compensation for the decreased yield, the union government has already banned the exports, which has resulted in losses to the farmers.
Agriculture economist Devendra Sharma, however, insists Indian farmers did not really benefit from the global wheat shortages in the first place.
अगर सरकार एक काम करती कि वो सारा स्टॉक किसानों को एक अच्छा दाम देकर प्रक्योर करके एफसीआई का काम ये होना चाहिए था कि वो जो है प्राइवेट ट्रेडर्स को आगे वो बांटता ताकि वो आगे एक्सपोर्ट कर पाते, लेकिन वो किसानों को कम से कम उसमें एक जो फायदा है वो सुनिश्चित हो जाता।
Meantime, demands for immediate rollback of the export ban have begun to grow.
ਜਿਹੜੀ ਸੈਂਟਰ ਸਰਕਾਰ ਨੇ ਕਣਕ ਦੀ ਐਕਸਪੋਰਟ ਬੈਨ ਕਰਤੀ ਹੈ, ਆ ਇੱਕ ਬਹੁਤ ਵੱਡਾ ਧੱਕਾ ਕਿਸਾਨੀ ਦੇ ਨਾਲ ਹੋਇਆ, ਬਹੁਤ ਵੱਡਾ ਨੁਕਸਾਨ ਹੋਇਆ ਹੈ। ਆ ਨੁਕਸਾਨ ਪੂਰਾ ਹੋ ਸਕਦਾ ਸੀ ਰੇਟ ਵਧਣ ਨਾਲ, ਪਰ ਰੇਟ ਇਹਨਾਂ ਨੇ ਵਧਾਏ ਨਹੀਂ, ਤਾਂ ਘੱਟ ਤੋਂ ਘੱਟ ਹੋਣਾ ਜ਼ਰੂਰੀ ਹੈ।
On its part, the central government has extended the wheat procurement deadline till May 31st. But for some farmers in India's food bowl states, the export ban appears to be unpopular for now. With Manjeet Sehgal in Mohali, Bureau Report, India Today.
So how should we see the government's U-turn on wheat export? Joining me now is the country's leading agricultural economist, Dr. Ashok Gulati, Infosys Chair, Professor, Agriculture and former Chairman, Commission for Agricultural Costs and Prices. Appreciate your joining us, Dr. Gulati, always. The government bans wheat exports with effect from May 13 with some minor exceptions for those who have irrevocable letters of credit or where the importing governments request the Indian government for food security. You had warned against such a decision. You are still critical. Can you tell us why you're critical of this wheat export ban?
Well, it reflects very poorly on what the Prime Minister had been talking, what the Commerce Minister had been talking, and what India was showing to the world, that our farmers are ready to feed the world. So it cuts a very sorry picture. Once we have committed for 10 million tons of exports and we have announced that publicly, I think we should have stuck to that. Nudging from that reflects a very poor decision as far as I'm concerned, besides the fact that it is going to be anti-farmer.
I'll come to the end.
Will be the losers in this game.
So you believe that the government should have stuck to its line of of exporting wheat using the opportunity provided by the Ukraine war in a way. But the government, sir, has defended its decision, saying there is a worldwide surge in inflation. India is not exempt from that. April 22, wheat inflation almost 10% against overall cereal inflation of 5.96%. There is a fear that wheat prices would have shot up even further. This is one step to check price rise. How do you see that?
Well, I don't think they'll be able to control inflation just by banning wheat exports. The price rise, global price rise in wheat was well known even before the government started talking of increasing exports. And the very fact that Prime Minister, when he was talking to President Joe Biden, he was aware, and it was that we will be able to cool down the global prices by contributing our little bit. So global inflation and global price eruption is not something, a new variable that cropped up suddenly. This was well known, and India had decided and given its commitment in a way for 10 million tons of exports. Now reneging from that is poor.
But there are concerns, sir, about food security. Revised estimates of wheat production much lower than the estimated 111 million metric tons. Wheat procurement also much lower than what it used to be. Should we be looking at our food security first before exporting wheat across the world?
Sure, if the procurement is low, the market is offering 10% higher price than the minimum support price. Government could have offered to the farmers a bonus of 250 rupees a quintal or 300 rupees a quintal, and farmers would be happy to government as much as government wants. Even today, if they announce 300 rupees as bonus per quintal, then all those farmers who are still holding their stocks in the expectation of a better price would be happy to give it to the government. Does the government not want farmers' incomes to go up? It's as simple. Market is at present on the upswing, and the farmers must be given free access to the best markets in the world. If the government doesn't allow that, it is implicitly a tax on the farmer. And especially so when you have already given free food to more than 800 million people in this country. So whom are you trying to protect by suppressing the prices of wheat? It is you and me. I think it is this bias of urban class, urban consumers that keeps our farmers poor. So these are all the policies of implicitly taxing the farmers, whether it is stocking limits, whether it is export controls. These are hidden instruments of implicit taxation on the farmer. I think people should know in the power what is the trade policy.
Interesting the way you're putting it, that the middle class is being protected and the farmer in a way is not being allowed to take advantage of favorable market condition. But there are those who will say that to suggest that the farmers are being hit is an unfair charge. They say that farmers have already sold most of their produce, so their interests are protected. You agree?
Well, if the production was targeted 111 million tons, and even if the production is somewhat less than that, government has to tell us what is the final figure on production. Do you think that entire 90 million or 100 million has been sold in the market? Then you don't understand what goes on in the market. There is a lot of stock which is still with the farmers. There is a lot of stock with the traders, and saying that farmers have got their due and therefore now you can suppress the prices. Next time nobody will be buying from the farmers. Everything will come down to the government. Now tell me, if the price is going up, the price is going up for 100 commodities. Maize inflation is 13.4%. Why don't you ban the export of maize? The oilseed, edible oil prices are going up by 17-18%. What is the solution there that you have? So there are many other reasons of inflation at present because you had given too much of stimulus. The fiscal policy has been extremely loose for the last 2 years because of COVID and so on and so forth. I think we have to get back to the pre-COVID policy scenario. And at present, if you're trying to just buy wheat exports, I can bet your inflation is not going to come down. Don't worry. So it will take another 1 year or 2 years for inflation to get under control. And that will be through a major action on the loose monetary policy and the loose fiscal policy that are there. Just by putting the tap off on wheat exports can help you for 5 days, 10 days. And after that, you will see again, the inflationary pressures are very much there. It's a global phenomenon. Please try to understand this inflation. It's not just a localized scenario. If your production is down, please tell us what is the final figure on production front. And your procurement is down because the market prices are good. So why are you suppressing it? Offer them a better price and take it as much as you want.
Fascinating, Professor Gulati. I hope someone in government is listening to you. The wisdom of talking about open markets applies to everyone else but our Kisan. And maybe the middle class always has to be protected, but what of the farmer? Thank you very much, though, for joining us and sharing your view, however contentious that may seem. Thanks very much. Let's take a break. On the other side is our continuous coverage of the water emergency that is prevailing across the country. This time we are traveling to Akola in Maharashtra. Get Real India, the real stories on the news today. Back in a moment.
Make your media plan smarter with India Today Live TV on your connected devices. Amplify your brand with 100 million smart internet viewers. To advertise, mail us at sales@aajtak.com or call 9999 892171.
As Russia declared war on Ukraine, as the world was plunged again into crisis, with the only Indian team in the real war zone.
This is Mariupol. You hear a series. Hear this sound.
I will show you a quick, so to say, bombshell room tour.
I can smell the gunpowder in the air.
And without pause, India Today totally dominates viewership and smashes the competition. When it's the world's biggest news story, there's only one gold standard of journalism. When it's the world's biggest news story, there's only one gold standard of journalism.
Welcome back. Let's turn to our Get Real India series, stories that really should matter. Our continuing coverage on the water crisis spread across north, west and central India this summer. Today we bring you a ground report on Maharashtra's water emergency, where the State Revenue Department has informed the cabinet 270 tankers are supplying water to 3 parched regions of the state. This water crisis could only get worse, some say, in the days ahead if the monsoon doesn't come on time. Take a look.
Search for water is making people in Maharashtra take risks that they normally wouldn't consider. 5 people drowned while washing their clothes in a quarry in Deslapada village in Dombivali near Thane this month after their wait for tankers proved endless. The first call for help from the quarry to the police station was attended tragically by Officer Suresh Gaikwad, who did not know that the victims were from his own family.
इसी पानी की वजह से आज हमारे गांव में बहुत बड़ी दुर्घटना हुई है जिसमें 3 बच्चों की जान गई है, 2 लेडीज उनकी जान गई है। हमारे परिवार के लोग हैं, वो सदस्य लोग हैं, हमारे कुटुंब के सदस्य। लोगों को पानी का इतना प्रॉब्लम हो रहा है, हर एक दिन टैंकर मंगाना पड़ रहा है। टैंकर का खर्चा, टैंकर का पैसा देना आम लोगों के बस की बात नहीं रही है।
After this incident, what we're getting to see here on the spot that there are no villagers present, but there are fire marshals who are here to warn people not to come here because there can be serious incidents be repeated. At the same point of time, what we can see here is that what was left of the family of 5 is these sleepers which are present at the spot.
Like Deslapada, Bhavarpada village in Palghar district is also facing acute shortage of water. Around 100 families are dependent on one well.
एक तो तेचा त्रास, एक तो पाणी त्रास, एक तो ऊन फार, दिसाची ताई ऊन फार. तर तशी ती पाणी नाही तर होऊन. तसा तर 4-5 तास लागतो एक कुटुंबाला पाणी. आता अंगलाय पाणी नाही, ढोराला पाणी नाही. तर त्या खं भरायला लागे ना, नाही सांबाई तर पाणी नाही.
In Akola's Kavta village, Man river has gone dry. People are digging the riverbed and drawing water. Farmers who work in their farms in the morning stand in queues to fill water in the afternoon.
आमच्याकडे कोणीच लक्ष नाही देत. आमची पिढ्यानपिढी अशीच चालली, झिऱ्याचं पाणी भरभरून.
किती वर्ष झाले?
लय झाले, 40-50 वर्ष.
Even fire trucks are deployed to provide water. This because there is a shortage of tankers. People of Devpur, a village in Dhule district, allege corporators are controlling distribution of water. According to them, one tanker costs around 1,500 to 2,000 rupees. But even if they are prepared to pay, there is no ready supply.
10 दिन के बाद 10 दिन से पानी आयल नहीं. वालमैन को बोले, वालमैन बोलता कि बाबले भाटे को कुछ भी लीकेज का काम चालू है. हर महीने में 2-3 बार नवे टेंडर निकलते लीकेज के. कॉन्ट्रैक्टर क्या कर रहे, नगर सेवक एक भी ध्यान देने तैयार नहीं.
Water tankers are the lifeline during summers for the people of Maharashtra. The state government claims over 270 tankers are supplying water to 281 villages and 738 smaller hamlets. The efforts, however, are not providing good enough on the ground. With Mustafa Sheikh, Bureau Report, India Today.
So yesterday our story was from Gujarat, which was BJP ruled. Today from opposition ruled Maharashtra. Water cuts across all political boundaries. Get Real India. And Get Real India is our image also. It comes from Assam, where incessant rains have triggered floods and landslides affecting over 2 lakh people in 20 districts. Road and rail links cut off by heavy rains and flooding with landslides. I know in some parts of Assam this almost seems like an annual ritual, but that's no reason why we should not be worried about what's happening in Assam. These are the stories that matter. Think about it. Stay well, stay safe. Good night, goodbye. Shubhratri, prayers for the people of Assam today. Bye for now.
Do you know of Amway products? And if you do, then how were you introduced to it? Was it a friend, a co-worker who introduced it to you? You certainly must have not found it on the shelves. Well, this is because their products are primarily distributed through a network of maybe 4 million members in over 100 countries. The beauty and wellness products company, Amway, is now under fire by the Enforcement Directorate for running a pyramid scheme. ED has also added that Amway's purpose is not to sell its exorbitantly priced products, but instead to induce the public to sign up as members of its get-rich schemes. And this led to ED attaching assets of Amway India Enterprises Private Limited worth over 757.7 crores following a money laundering probe under the Prevention of Money Laundering Act, the PMLA. Is Amway a pyramid scheme? Well, pyramid schemes might look like they are built around legitimate products, but the goal really is usually just to get as many people enrolled as possible. The scheme participants go to extreme lengths to recruit new members, taking persistence and pressure to uncomfortable levels. The point of the scheme is really never about selling the products. It's simply about enrolling increasing number of people, all of whom are required to buy products. They make money based on recruiting an ever-increasing number of investors. The initial promoters recruit investors who in turn recruit more investors, and so on goes the cycle. The